Hello, my name's Anthony Hopkins. I'm an Associate Professor here at the ANU College of Law. I'm also a barrister, criminal defence barrister. Here at the ANU College of Law, I teach evidence, and we teach evidence by way of a mock trial that runs throughout the semester. In today's trial, I'm playing the role of presiding judge.
My name is Sophie Elder Harris. I'm a third year law and political science student, and I was playing the role of the Crown Prosecutor today.
My name's Andrew Ray. I'm a Bachelor of Laws Honours Science student in my final year studying at the Australian National University, and I am playing Defence Counsel in today's trial.
My name's Charlotte. I'm a penultimate year Law and Economics student, and I'm playing the wrongly accused defendant in this mock trial.
My name is Callum Wilson. I'm a third year Bachelor of Law and Political Science student, and today I played the role of the innocent victim.
Yes.
All stand. This Honourable ANU mock court is now in session in the matter of the Crown against Bronson, with Justice Hopkins presiding. Please be seated.
Yes, Counsel, would you like to announce your appearances, please?
Miss Elder Harris for the Crown.
Miss Elder Harris.
Mr. Ray for the defence.
Thank you, Mr. Ray.
Thank you, Your Honour.
Mr. Ray, would Miss Bronson like to enter a plea?
She would, Your Honour.
Yes, so Ms Bronson, if you would stand. Ms Bronson, you've been charged with assault occasioning actual bodily harm. To that charge, how do you plead?
Not guilty, Your Honour.
Thank you, Ms Bronson. You can take a seat. Members of the jury, you've come here today to take on a very important role on behalf of the community. The prosecution has charged Jen Bronson with assault occasioning actual bodily harm, and it will be for you to determine whether Ms Bronson is guilty. Prosecuting counsel is Ms Elder Harris, who you heard from just before, and defence counsel is Mr Ray. I'm the judge presiding this matter, and my name is Justice Hopkins. It's important that you understand that my role is to ensure that there is a fair trial and that the rules of evidence are followed. I decide any questions of law. Your role as a jury is to decide questions of fact. You are the sole judges of the facts. You will decide whether Ms Bronson is guilty or not guilty. Shortly you will hear an opening address by both counsel. The purpose of this address is to assist you to understand the issues in the case and the evidence. What counsel says to you is not evidence, or what counsel say to you, I should say, ladies and gentlemen, is not evidence. Now, after the opening addresses, the Crown, which is another way of referring to the prosecutor, will call any witnesses she proposes to call. You will be hearing from Jack Lee, who the Crown says was the victim of the assault. After the Crown case is concluded, the defence may call a witness. The defence does not have to call a witness because in our system of criminal trial, it is for the prosecution to prove the offence and each element of the offence beyond a reasonable doubt. It is critical that you understand that Ms Bronson is presumed innocent until the case against her is proved beyond a reasonable doubt. After you've heard the evidence, both counsel will make a closing address. Again, these are designed to assist you in determining the facts. Following these addresses, you will retire to the jury room to deliberate and decide on your verdict. Madam Crown, would you like to proceed with an opening address to the jury?
Your Honour, members of the jury, as will be made clear today throughout the trial, this case is simply one of an unprovoked revenge attack, for which the blame lies solely on the defendant, Ms Jen Bronson. As we will prove today, beyond reasonable doubt through witness testimony, following an incident involving a spilt drink, words were exchanged between Mr Lee and Ms Bronson in the playground bar in Civic. Following this minor incident, Ms Bronson waited outside in the cold for Mr Lee to emerge from the bar. She then accosted him in a dark alleyway. Mr Lee, a small man, fearing for his safety, attempted to bluff his way out. Tragically, he was unsuccessful. Miss Bronson punched him in the face, knocking him out with a single blow. The defence would have you believe that she did so in self-defence. Simply put, this cannot be the case. Mr Lee was not threatening Miss Bronson, and even if he was, she could have backed out of the alleyway rather than resorting to force. Critically, Miss Bronson did not call for help, shout, or otherwise attempt to flee. Instead, her use of force left Mr. Lee with a laceration under his left eye, a wound he may now carry for the rest of his life. In deciding whether Miss Bronson is guilty of assault occasioning in actual bodily harm, I call on you to keep in mind the innocent victim on the events of the 15th of September 2019. Now, I know that these are uncertain and troubling times, and for this reason you, the jury, are being streamed into this court virtually. But in undertaking your duties today, put yourself in the shoes of the victim. A 19-year-old university student just out of high school, viciously attacked in a dark alleyway. It is victims such as this that the justice system must serve and protect. Thank you, Your Honour.
Yes, thank you, Ms Elder Harris. Mr Ray, an opening for the defence.
Your Honour, members of the jury, the prosecution would like you to believe this is a simple case, a matter where my client, Ms Bronson, attacked a larger man in a dark alleyway, viciously drawing blood and leading to the scurrilous charges brought against her today by an overzealous prosecution. The simple fact was, members of the jury, that as witness testimony today will show, Ms Bronson, who is significantly smaller than the complainant, was scared for her life and her person when Mr Lee, a trained fighter, threatened her, shouted at her, and backed her to the corner of a dark alleyway. Alone and surrounded, she did the only thing she thought she could in that situation, to act swiftly to remove the threat by striking first. In doing so, members of the jury, she used reasonable force, striking the rugby-playing karate master Mr Lee once in the head. She did not continue to hit him once he was on the ground, but instead stayed at the scene and cooperated fully with the club bouncer and the police. I compel the members of the jury to consider whether these are the actions of a guilty woman. Simply put, the evidence at its highest cannot prove that Ms Bronson's punch caused the cut to Mr Lee's face over the ruckus that he was engaged in earlier on the night in question. Ultimately, however, this is a matter of self-defence, and we would submit to the members of the jury that Ms Bronson must be acquitted on all charges on this basis. I ask you to consider what is more likely: the slightly tipsy carpenter's apprentice attacking a much larger man in an alleyway unprovoked, or that Ms Bronson, acting in self-defence, used the minimum force necessary to remove a threat. Ask yourselves what you would do if confronted with the same situation. Thank you, Your Honour.
Yes, thank you, Mr Ray. Madam Crown, would you like to call your first witness?
We'd like to call Mr. Jack Lee.
Yes, Mr Lee, if you just remain standing for a moment. Now, will you be taking an oath or an affirmation today?
An affirmation, Your Honour.
So please read the statement as set out on the table in front of you.
I solemnly and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Thank you, Mr Lee. You can take a seat now and just make yourself comfortable and the questioning will proceed. Yes, Ms Elder Harris.
Thank you, Your Honour. Please state your name, age, occupation and address for the court.
My name is Jack Lee. I am 19 years of age and reside at an address currently known to police. I am currently studying a Bachelor of Arts at the ANU.
Would you please tell the court what happened on the 15th of September 2019?
On the 15th of September 2019, after a rugby league grand final, I went to the Playground Bar in Garema Place in Civic.
What position do you play on your rugby team?
Since I'm only 165 centimetres tall and only 60 kilograms, they put me out on the wing.
Now, taking you back to the events of the 15th, when did you arrive at the bar?
I arrived at around 8 p.m. I spent the whole afternoon with an ice pack on my face after sustaining a hit during the game. I was so sore that I didn't really feel like going out. I couldn't even have dinner.
And what happened after you arrived at the bar?
After I arrived at the bar, I had a few drinks with my mates, maybe 6 or so vodka cruisers. At about 10 p.m, I accidentally knocked over a glass of red wine belonging to a person I now know to be the defendant, Jen Bronson.
And what did Jen say to you?
Objection, Your Honour. Leading a question presupposing a factual issue. Namely the fact that words were exchanged at all.
Yes.
I will raise the question, Your Honour.
Thank you, counsel.
After you knocked over the drink, what happened?
After I knocked over the drink, she turned to me and said, "You'd better watch your back."
Sorry, objection, Your Honour. Again, this time on the ground of hearsay. I would submit, Your Honour, that this evidence is being adduced for a hearsay purpose, namely to suggest to the jury that my client threatened the complainant. We would accept, however, that this evidence could be adduced for a non-hearsay purpose, namely the effect of the statement on the complainant himself. And in that circumstance, I would seek a direction pursuant to section 136 that the evidence be limited to that purpose.
Yes, Ms Elder Harris, what do you say about the proposal that the evidence be admitted but there be a direction in relation to its use?
We would not oppose such a direction, Your Honour.
Yes, thank you. You may continue.
How do you feel after hearing this statement?
So, I'd never met the defendant before. She was intimidating and a little older than me. She was slurring her words and red in the face. She looked pretty drunk to me, so I apologised and moved away.
What happened after you moved away?
One of my friends, Mark Burrows, he told me to watch out. He told me that the defendant likes to beat people up for getting in her way. I didn't think anything of it until later that night.
Sorry, objection once again, Your Honour. On three grounds this time, Your Honour, namely relevance, unfair prejudice and hearsay. Clearly, Your Honour, even if this statement were true, and we're not conceding that fact, members of the jury, it could not rationally affect the assessment of a probability of a fact and issue in today's proceedings. Simply put, my client is not being charged with beating up unspecified people, several months before the events of the 15th of September. Instead, she's only been charged on a single assault on the night in question, and her earlier behaviour is therefore entirely irrelevant to today's proceedings. Furthermore, were Your Honour to find the evidence relevant, I submit that the unfair prejudice outweighs its probative value pursuant to section 137, especially because it is hearsay evidence.
Yes, very well. What do you say about this, Ms Elder Harris?
Your Honour, I don't think we'll try and contest all the objections and we'll withdraw the question.
Very well. We'll proceed then.
Did anything happen later that evening?
After having a few more drinks, I left Playground Bar at around 11:30 on my own. As I walked away from the bar towards Bunda Street, Jen came at me from a dark alcove in the laneway. She had her fist raised and I was scared. I thought I'd try and bluff, so I screamed out, "Come on, I'll fight you." I didn't want to fight her, but I didn't know what to do. I don't go around hitting people.
What happened after the police took your statement? Sorry, what happened after you shouted this? My apologies.
When I was younger, I used to take karate classes, but I only made it to the level of orange belt. But what I remember from karate didn't help me that night against the defendant. I just stood there and she kept coming at me. She then punched me in the face and knocked me to the ground. I think she knocked me out. When I came to, she was being restrained by a bouncer, shortly after which the police arrived, arrested the defendant and took a statement from me.
And what happened after the police took your statement?
I received some medical treatment for severe bruising and a laceration under my left eye where the defendant hit me.
Thank you, Mr. Lee.
Yes, thank you, Madam Crown. Mr Ray, is there any cross-examination of this witness?
Yes, Your Honour.
Yes, please.
Thank you, Your Honour. Now, may I call you Jack?
Yes.
Thank you. So, Jack, you sustained a hit in the rugby game earlier that day, hadn't you?
Yeah, I did.
And that was to your face, correct?
Yes.
And the hit was so hard that you were unable to eat anything that day?
Yeah.
Yeah. And so I'm just questioning, if you'd sustained that hit to your face, how do you know that the injuries you received, treatment for later that evening, were in fact caused by my client?
Because of how hard she hit me.
But isn't it possible that the injuries were in fact caused by the rugby game earlier that day?
I guess.
Yes. And look, just once again to confirm, you hadn't eaten anything since lunchtime, is that correct?
Yeah.
And you weigh only 60 kilos?
Yes.
Or rather, sorry, you did at the time?
Yes.
Yes. Now, on the evening of the 15th, you'd consumed a substantial amount of alcohol, hadn't you?
I wouldn't call it substantial.
Wouldn't you? You had about 9 drinks between 8 p.m. and 11:30 p.m. that evening, hadn't you?
Maybe. I can't quite remember.
Now, Jack, you're a man who can count, right?
Objection, Your Honour. That is an improper question under section 41(1)(c), which disallows questions that are belittling or insulting. Clearly the witness can count. He is enrolled at ANU.
Counsel.
Yes, I will rephrase the question. My apologies, Mr. Lee. Now, Jack, when you said to police you'd consumed a few drinks, how many do you mean? 2, 3, 4, 5?
Probably 2 or 3.
Right. And so if we go off that number, you'd had 6 drinks before the first incident with Ms. Bronson, and 2 or 3 later that evening for a total of 8 or 9 over a few hours?
Yeah, I guess that's correct.
So you were drunk?
I would say that.
Mr. Lee, just to confirm to the court, and I will remind you, you are under oath, you had not eaten anything all day, you weigh only 60 kilos, and you consumed 8 or 9 drinks over a 3-hour period. Is that correct?
Yes.
So you were drunk?
Objection, Your Honour, badgering the witness. This question has been asked and answered 3 times now. The jury surely does not need to hear this line of questioning again.
Yes, thank you, counsel. What do you say to that, Mr. Ray?
Your Honour, I'm merely asking this question in response to the new evidence that we've just adduced under cross-examination regarding the precise number of drinks Mr. Lee had consumed. Now, as was established by my learned friend earlier, the witness can indeed count, and I'm simply determining whether he wishes to adjust his answers as to the state of his sobriety on that evening.
Well, counsel, I'll allow the question, but counsel, you're skating on thin ice with heated shoes, so please watch yourself.
I will bear that in mind, thank you, Your Honour. So, just to confirm, you were drunk?
No.
Objection.
Yes, I think we've gone about as far as we can with that line of questioning.
Very well, I will move on. Mr. Lee, why are you lying to the court?
Objection, Your Honour. Again, this is an improper question. My learned friend is harassing the witness. It is simply beggar's belief to accuse my witness of lying under oath without any evidence to support this proposition.
Yes, Mr. Ray, what do you say about that?
Your Honour, I'm simply trying to test the evidence and determine the reliability of this witness. To borrow the words of my learned friend, it simply beggars belief, Your Honour, that this witness was not drunk on the evening of the 15th of September, having consumed that amount of alcohol and only weighing 60 kilos.
Well, counsel, that may be true, but I'm not going to allow this line of questioning. I think that'll be a matter for your closing address to the jury.
Very well, thank you, Your Honour. Now, in the bar, after you knocked my client, you said your drink mate, your loss, didn't you?
No.
And in response, the defendant said, "Whatever, you idiot," didn't she?
I don't recall that.
I just have a couple more questions then. I'm going to take you to the laneway before my client allegedly knocked you out. You shouted, "Come on, I'll fight you," didn't you?
Yes.
In fact, you screamed those words.
Yes.
So you wanted to fight Ms. Bronson?
No, I didn't. I was just trying to bluff.
A bluff. So when you screamed those words, "Come on, I'll fight you," your purpose was to scare my client, Ms. Bronson, wasn't it?
Yes.
Yes. And that's because you didn't want to fight.
Yes, I did not want to fight.
You did not want to fight. And after you screamed those words, and only after you screamed those words, the defendant approached you. Is that correct?
Yes.
Now, I need you to remember very carefully here. At this point in time, your hands were raised in front of you, like so. Is that correct?
I don't think so. I can't recall it. It all happened so quickly.
Just one more question. Thank you for bearing with me, Mr. Lee. You learnt karate for a number of years, didn't you?
Yes, that is correct.
No further questions. Thank you, Your Honour.
Yes, thank you, Mr. Ray. Any re-examination?
No, thank you, Your Honour.
Thank you, counsel. And does the Crown propose to call any further witnesses?
No, thank you, Your Honour. That concludes the Crown's case.
Thank you, Miss Elder Harris. Yes, Mr. Ray, do you propose to call any witnesses?
Yes. Unusually today, Your Honour, we will be calling the defendant, Ms. Bronson, to the stand.
Yes, Miss Bronson, if you would just remain standing for a moment. Will you be taking an oath or an affirmation today?
An oath by the Almighty God, Your Honour.
Yes, well, please take the oath as set out on the table in front of you.
I promise by Almighty God that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Bronson. You can take a seat and make yourself comfortable. Mr. Ray.
Thank you, Your Honour. Can you please state your name, age, address, and occupation for the court?
My name is Jen Bronson. I'm 22 years old. I'm an apprentice carpenter and I live at 20 Bundy Crescent, Waniassa.
Thank you. And Ms. Bronson, what happened on the 15th of September 2019?
I was at Playground Bar around 10 p.m. I'd had a couple of red wines, but I wasn't drunk. Then this guy comes up to me and just bumps into me on the dance floor and spills my drink all over me. I didn't see him coming, but it was a pretty hard knock. I looked around to see who he was and to see if he was going to apologise. That guy, Jack Lee, just glared at me and said, "Your drink, mate, your loss."
Objection, hearsay. Your Honour, this statement is being adduced to prove the truth of a statement made by Jack Lee and therefore is not admissible under Section 59.
Yes, Mr. Ray, what do you say about that?
Your Honour, we are simply adducing this statement for a non-hearsay purpose, being the effect of Mr. Lee's statement on the defendant, and therefore the hearsay rule does not apply.
All right, I'm going to allow it.
Thank you, Your Honour. Sorry, Ms. Bronson, please continue.
I'd never met him before, but I know his name now. He looked pretty drunk to me and like he wanted to fight. He had cuts and bruises all over his face. I just said, "Whatever, idiot."
And what did you do after this interaction?
Well, then I walked away. After that, a friend of mine, Simon Beasley, came up to me and told me to watch out for Jack. He said that Jack's team had just lost the grand final and he was pretty angry. Simon also told me that Jack was a karate expert. I didn't see Jack again inside the bar.
Objection, Your Honour, hearsay. This is being adduced to prove the truth of a statement made by Simon Beasley and therefore is not admissible under Section 59.
Yes, thank you, counsel. Mr. Ray, what do you say about this objection?
Your Honour, once again, we're adducing this statement for a non-hearsay purpose, being the effect of the statement on the defendant. And it goes to the question of self-defence in today's proceedings, Your Honour. I can take you to the case of Subramaniam against the DPP.
Counsel, that won't be necessary. I'm quite familiar with that case. I'll allow the question and the response. In my view, there is a clear non-hearsay purpose.
Thank you, Your Honour. Now, Ms. Bronson, what happened later that evening?
Well, later that night, I'd had a few more drinks and I was outside playground having a cigarette with Simon. We were standing sort of closer to the Bunda Street end of the laneway. Simon went to get a kebab and left me alone.
And that's when you saw Jack again, didn't you?
Objection, Your Honour, leading question. The question is suggesting to Miss Bronson an answer, namely that she saw Mr. Lee. If my learned friend wishes to testify as in today's matter, then he should take the stand himself.
Yes, that's a reasonable point. What do you say about that, counsel?
I'll rephrase the question.
Yes, thank you, Mr. Ray.
To my learned friend that I'm not wishing to testify in today's proceedings.
Yes, of course, Mr. Ray.
Thank you. Now, Ms. Bronson, what happened after Simon left you? Left you that evening?
Well, as I was standing there, I saw Jack come out of Playground Bar. I was still a bit upset and I just wanted an apology from him. As I walked up to him, he screamed out, "Come on, I'll fight you." Then he came at me with his hands up in a kind of kung fu position. I tried to back away, but I was up against a wall and I got really scared. I just punched him really quick. I hit him as hard as I could because I knew I had to finish the fight then and there before he could get all karate on me. I just thought I'd take him by surprise. I punched him in the face. He just fell to the ground and I stood back until a bouncer arrived. I then made a statement to the police and was arrested.
Thank you for your courage in testifying in today's proceedings, Ms. Bronson. No further questions. Thank you.
Thank you, Mr. Ray. Yes, any questions, Ms. Elder Harris, in cross-examination?
Yes, thank you, Your Honour. So, Miss Bronson, you brutally punched Mr. Lee, didn't you?
No, it wasn't brutal. I was protecting myself.
But you did knock him out?
Well, I'm not really sure. He fell to the ground and I moved away, but even if I did, he couldn't have been out for long because he made a statement to the bouncer.
You punched him in his left eye, didn't you?
I don't remember. I was just aiming for his face. As my parents told me, if you have to fight, one punch to make it count.
You had an interaction earlier the evening, am I right?
Yes.
Where you called the complainant an idiot, didn't you?
Yes.
And you were aggressive when you said this?
Well, he bumped me and spilled my drink everywhere and didn't even apologise, so I was a little annoyed. Red wine stains are really hard to get out of Kashmir.
Yes, it is. I agree. Later that evening, you saw Mr. Lee leave the bar, didn't you?
Yes.
Now, at this point, you had eaten your kebab and you'd left your friend, right?
Yes.
And you stayed in the alleyway alone?
Yes.
And this was because you wanted to fight Mr. Lee, wasn't it?
No, I was just waiting for a mate.
And it was at this point you rushed towards him.
I wouldn't say I rushed.
But you did approach him, correct?
Yes.
And to be very clear for the jury, he was not the one who approached you.
No, but as I walked towards him, he shouted at me, "Come on, let's fight."
Now, Miss Bronson, to be clear, you approached Mr. Lee down the alleyway, didn't you?
Yes, I already told you that.
As you approached him, you had your fist raised, didn't you?
No, I don't think so.
Mr. Lee has testified that he saw you with your fist raised. So I want you to think very carefully here. Are you sure you did not have your arms up?
Like I said earlier, Mr. Lee was very drunk, so how he could see anything is beyond me.
Bear with me here. If you approached him, that means that there was space behind you.
No, I was against the wall, trapped.
Sorry, Miss Bronson, but if you approached Mr. Lee by coming down the alleyway, how is it possible then that there was not a space behind you that you could have run to?
Well, I don't know, but my back was against a wall and I was scared.
And at this point, you punched Mr. Lee, correct?
Yes, I was scared.
And he hadn't given permission to you to hit him, did he?
No.
And he hadn't threatened you physically, had he?
He was like in a karate position and he said, "Come on, I'll fight you."
But he wasn't swinging his arms at you or anything, was he?
No,
And he was quite drunk and not moving quickly, correct?
I guess so.
And in fact, you made up this story about approaching him to get an apology, didn't you?
No, I just wanted an apology.
Miss Bronson, what you wanted was revenge, wasn't it?
No, that's not true.
No further questions, Your Honour.
Yes, thank you, counsel. Is there any re-examination?
No, thank you, Your Honour.
Yes, and is that the close of the defence case?
Yes, Your Honour, that closes the case for the defence.
Yes, all right. Thank you. Miss Elder Harris, do you wish to make a closing address to the jury?
Well, thank you, Your Honour. Your Honour, members of the jury, the defence has had their chance to present their case, and we have heard from both witnesses. Though the motivations behind the actions differ between accounts, the court has heard that Mr. Lee and Miss Bronson were both present in the Playground Bar on the 15th of September 2019. Mr. Lee knocked over Miss Bronson's drink, after which some words were exchanged. The two met again in a dark alleyway, where Miss Bronson struck Mr. Lee, leaving him with a laceration under his eye, which may result in a face-deforming scar. This is agreed by both witnesses under oath, and Miss Bronson admitted to the court that she hit Mr. Lee in the head and intended to do so. Members of the jury, this is assault. The question of Miss Bronson's guilt or innocence therefore revolves around one disagreement of fact. Was Miss Bronson acting in self-defence when she hit Mr. Lee? The question to answer is, were her actions necessary? The answer to which is no. She had ample opportunity to call for help or back out of the alleyway. Instead, she chose to stay and punched Mr. Lee unprovoked. Mr. Lee, in contrast, I remind the jury that he is a small man. He was an orange belt, which in karate terms meant that he was just good enough to know how he was not actually very good. He had a bright future, which he would be unwilling to jeopardise with a criminal record. Meanwhile, Miss Bronson was, by her own admission, upset with Mr. Lee and sought confrontation with him. Not only that, but she sought to end the so-called fight in a single punch. Simply, she intended to cause as much damage that was possible to inflict in such a short time as she could. Members of the jury, this case is one of a revenge attack, not a matter of self-defence. Thank you. Thank you, Your Honour.
Thank you, counsel. Mr. Ray, closing for the defence.
Yes, thank you, Your Honour. Your Honour, members of the jury, the case led by the prosecution in today's proceedings cannot, at its highest, establish the elements of assault. Simply put, Mr. Lee cornered my client, Ms. Bronson, in a dark alley. Mr. Lee then shouted at her, screaming the words, "Come on, let's fight." I repeat that, "Come on, let's fight." Members of the jury, this is a clear threat. In response to this threat, Ms. Bronson hit the complainant, a fact that is not contested by the defence. The key questions we are calling on you, members of the jury, to answer today, therefore, are: 1. Did Ms. Bronson believe it was necessary to do what she did to prevent herself from being attacked? And 2, was her response reasonable in light of the circumstances as she perceived them? The facts, as established by witness testimony today, clearly demonstrate that the answers to both of these questions must be answered in the affirmative, and that therefore my client, Ms. Bronson, must be acquitted on all charges. Simply put, Ms. Bronson, when cornered in an alley by a drunk man, indeed a man so drunk that how he could see anything would be surprising to her, a man who had threatened her earlier in the evening, who had shoved her, who had spilt her drink, a man who she had been warned was a clear and present danger to her, used the minimum amount of force necessary to remove that threat, a single punch. Ms. Bronson then did an upstanding thing. She remained at the scene to render aid to that very man who had threatened her, and she then cooperated with police and with the bouncer. I repeat the line that I led in my opening address to the jury, that these are not the actions of a guilty woman. In contrast, Mr. Lee, the man who screamed at her, "Come on, I'll fight you," was a rugby-playing karate master whom the defendant had been told had quite a reputation for violence. Place yourself in her shoes, members of the jury, and ask yourself, what would you have done were you to have found yourself in that alley? Thank you, Your Honour.
Thank you, Mr. Ray. Ladies and gentlemen, you've heard the evidence, you've heard the opening and closing addresses of counsel, and it's now come time for you to retire and consider your verdict. Before you do, I simply remind you that in our system of criminal trial, the prosecution must prove its case beyond a reasonable doubt. Now, both counsel have narrowed the issues for you, and it appears that this case is to be resolved on a question of whether or not Ms. Bronson was acting in self-defence. As counsel for the defence has told you, the key questions for you to consider are whether it was necessary for Ms. Bronson to do what she did, and whether, in particular, whether she believed it was necessary, and whether it was a reasonable response in the circumstances as she perceived them to be at the time. Now, what's also important for you to know is it's not for the defence to prove this case. It has been raised on the evidence, and it was a matter for the prosecution to disprove beyond a reasonable doubt. So in order to find Ms. Bronson guilty, you would have to be satisfied beyond reasonable doubt that she was not acting in self-defence. That is a matter entirely for you. Hello, my name's Anthony Hopkins. I'm an Associate Professor here at the ANU College of Law, where I teach evidence. I'm also the Director of Clinical Internship Courses here for the Law School. On top of that, I'm a criminal defence barrister, so I bring all these things to the teaching approach that we adopt in evidence. And one of the key things about ANU is that we understand that law is often best learned in action. So it's important that in our teaching and in the opportunities we give students, there is a chance for students to apply their knowledge either in simulated settings or in the real world to make a real difference. One of the examples of doing experiential learning, as it's often called, takes place in evidence, where we run a semester-long trial in which the students are prosecution and defence counsel and also play the roles of witness. And in that course, the premise is that the practical process of proof is best learnt with you, the student, behind the wheel of the vehicle, the driver's wheel, learning, making mistakes, and learning in action. We also have a moot program, mock trial program, and other courses that are designed to take you into law in the real world. And that includes working in host organisations in Australia, locally, nationally, and also internationally. NGOs, government, law firms, you name it, there are opportunities for you to apply your legal skills in ways that make a real difference. And the aspect that's important to know about this is your experience at law school. This is your opportunity to determine what fits you best, what suits and what accords with your values. And so through these experiences, we both link theory and practice, but give you the opportunity to determine your own future.